All right, everybody, welcome to bail source hearings. Ooh, that sounds sounds very complicated. Assistant Prosecutor Sean McMurtry is here to tell us all about it. I got a couple questions for you, by the way, about this.
Okay.
Let's say, for the sake of argument, that I'm an attorney. My client has been arrested and charged with some type of drug mess.
Okay.
And I walk over to the Mercer County clerk, and I say, Mercer County clerk, my guy's being held on a $100,000 bail, no 10%. Here's a cashier's check for $100,000. Please release my guy.
I'm out.
And have a nice life. Would that raise any hackles with the Mercer County Prosecutor's Office?
Of course. Especially since it's you, Bob. Well, first and foremost, if it's $100,000 cash or bond, we're probably talking about a first or second degree drug offense.
Absolutely.
Which is a bail restricted crime.
I don't even get out of bed for a third degree crime.
Okay. All right. Again, when we go through this, if you're talking about a situation where you've likely got a first or second degree narcotics case because bail's that high, it's a bail restricted crime. It needs a bail source form. The 8-page form must be filled out and submitted. They won't just, it's not like they accept your check and give me a call. You have to fill out a form and send it to me, and then I review it. If the form on its face includes information about the source of the money and the money is completely legit, no, there's no problem. We send the letter to the workhouse, it's approved, you get them right out. Sometimes we need additional information. We'll say we have questions about the source. We need a bank statement. We need a pay stub. We need some information about where the money came from. Right. And then that day or the following day, the information is provided. It looks legit, and then we approve it. Sometimes we don't get the information. They're like, it doesn't exist. Or they're just like, no, we're not going to answer that. That raises red flags, and then we may go to a hearing.
Okay, so it's kind of automatic for the first and second degree crimes, I would imagine.
They have to submit a form, not necessarily have a hearing. The law has changed over the past several years. You may recall in the early 2000s, they passed a law allowing for bail source hearings if requested by the prosecutor.
Right.
Okay? That was in any case.
Yeah,
okay?
we used to do it in municipal court, as I recall.
Yeah, all right, that was in any case. Then in 2007, they amended the law to include the bail source form, the inquiry questionnaire.
Right.
Okay? So it's not like we automatically go to bail source hearings now. Now when you have a bail restricted crime, which is typically the first or second degree serious crime, the individual attempting to, put up the bond has to fill out this form, send it to us. We review it. If we think it looks legit, we approve it, and they're out. Only if we think there's a problem or we have questions or concerns would we then request a bail source hearing.
I have to correct one thing I said very quickly. It was not bail source hearings that we did in municipal court. It was the drug restraining orders that we did.
Oh, yes.
And then there was a change in the law, and they don't happen in municipal court anymore. Now, does it change the calculus in the little example I gave you that instead of the attorney showing up with $100,000 in cash or a cashier's check, whatever it may be, it's a bail bondsman? Okay.
No, it doesn't change the equation at all.
Okay.
Again, because if you're talking a bail-restricted crime, and we'll go over those in a minute, what they are,
right,
under 2A 162.12, okay? If it's a bail-restricted crime, no matter who it is, a private individual, the defendant themselves, an attorney, a bail bondsman, it doesn't matter, they must submit a bail source inquiry questionnaire for review.
Now, my final question on this before we get into the actual substance of Rule 326.8 is, how about property bonds? Does that ever come into play where there's an issue on a property bond?
Property bonds come into play, yes, usually without a bail bondsman. Individuals, I just had one a few weeks ago. The statute basically says if they're going to put up a property bond to bail someone out, the county council has to confirm that there's good title to the property.
Right. They
essentially do a title search. And they have to guarantee that there's unencumbered equity equal to and including $20,000 beyond the amount of the bail. So if you've got a $100,000 cash or bond bail, they have to put up equity that has a demonstrated unencumbered amount of $120,000 minimum.
So the assessed value of the property that's out. Doesn't mean anything anymore.
I'm sorry,
the assessed value of the property.
No, the assessed value. The assessed value is a factor, of course. I mean, if the assessed value is only $40,000, it's not going to be accepted for a $100,000 cash or bond bail.
All right, but if the market value of the property is 50 and the bail is only 30,
yes,
then you're okay, I guess.
Provided that 50 is unencumbered.
Unencumbered, right?
Okay, all right.
No.
I just had a bail source hearing last week where the bail bondsman says it's it was $200,000 cash or bond
Right.
on an attempted murder case.
Right.
Where the guy had a prior homicide conviction.
Well,
and yeah,
that's what the cops say. You know.
But I
want to wait till all the evidence is
the
in.
bail bondsman accepted $3,000, $3,000, and was going to put up $200,000.
They're going to write a bond on only $3,000
on $3,000,
Oh, wow.
and it happens all the time, and I'll explain why about the techniques of what goes on in the bail bond business.
Right.
But the bail bondsman was called to testify because he says, "Well, we're taking property. We have a mortgage. The defendant's sister, who was putting up the $3,000, also is putting up a mortgage on the house. They own a house in Bordentown,
okay.
and they're putting up a mortgage on the house to help cover us, the bail bond company." Bail bondsman, did you do a title search? No, we did not. Do you know the value of the property? Well, we looked up something on the internet. It's got a value of like $220,000. Do you know if there's any liens or encumbrances on it? No, we don't. Do you know if there's a mortgage on it? No, we don't. Did you even try to check? No, we didn't. Then they called the sister who owned the house with her husband. What's the house worth? Well, what'd you pay for it? We paid $285. How much did you mortgage? $285. How long have you had the house? 7 years. What's the value? Well, it's gone down. It's worth $220 now.
So we're underwater.
So, is your mortgage more than the value of your house? Yes, it is. Bail bondsman, are you still willing to take that? Yeah, we don't care. That was their response. We don't care.
Right, sure, because business is tough out there.
Business is tough. We just want the $3,000. We don't care.
Is it illegal in New Jersey to have a condition of bail where it has to be cash or property and not a bail bond?
Yes.
Can you do that?
Yes.
Or could that be a restriction?
There is the, again, there are under 2A 162.12, you can have a cash-only situation. It's a very narrow set of circumstances where you can get cash only. I think one of the circumstances is if the individual is charged with a bail-restricted crime and they have 2 open indictable matters.
Okay.
Whether they're indicted or not. If they're charged, maybe not indicted yet, you can ask for cash-only bail. If they have 2 or more prior convictions of a first or second degree and or a school zone, third-degree school zone offense, and they got a bail-restricted crime as the new charge, you can get cash only. Or if they have 1 prior conviction for any homicide or manslaughter, aggravated sex assault, or kidnapping conviction,
right,
and they're charged with a bail-restricted crime, you can get cash only. Or if they're on parole, you can get cash only.
So that would be a motion by the state to have a restricted bail, the cash-only bail under those circumstances.
The municipal courts, the desk sergeants don't know this. Typically, we're only getting that in situations where they come in, a few days after the arrest and they're still in the workhouse, and we do that morning video bail where we get them from the workhouse and they're on the screen down at our courthouse.
Right.
We will, if it's not already cash only, which it never is, we inform the judge we're asking for cash only because they meet one of those criteria.
Okay.
They've got their current charge is a bail-restricted crime, or it includes a bail-restricted crime. They have one of those prerequisites met. We're asking for cash only. The law says cash only is presumed. It shall be cash only unless the judge finds on the record that a lesser form of bail would ensure the defendant's presence.
Got it.
It's a presumption of cash only in those situations.
Okay, so it's really going to be on the defendant then to overcome that.
Yes.